Well, hello, everybody, and welcome to our McGuireWoods webinar. Today, our topic is the Department of Labor's new independent contractor rule. My name is Brian Barker, and I'm a partner in the Labor and Employment Group in our firm's Charlotte office. And joining me are my friends and fellow team members in our Chicago office, Dave Leishman and Mike Phillips. Thanks to everybody for tuning in. Before we move into the meat of our topic, let me just start with a few items about our platform and a few logistics. First, on your screen, you should see several icons. The resources icon includes a copy of the presentation itself. If you'd like, you could use it to download the deck to your desktop at any point during the presentation. You should also see a Q&A feature also on your screen. You can use that feature to submit any questions you have throughout the webinar, which we'll work to address at the very end. However, I'll be honest, we've got a lot to cover. If we don't get to your particular question, feel free to email us offline after the webinar is over. Our email addresses, both for me and Dave and Mike, are on the very last screen on the deck. They're also in the body of the e-bite that you received about the webinar itself. Second, please note that the presentation is being recorded. We'll send a link to the recording together with a copy of the deck. After the presentation is done, feel free to share that internally or externally with friends, neighbors, others who might be interested. The more, the merrier. So, with that, as for other logistics, during our time together today, we plan to cover 4 real items. The independent contractor sort of employee basics refresher, just a reminder sort of how we got here and what some of the underlying concepts are about the independent contractor test itself. We'll chat a little bit about the DOL test scope, its history, and an overview of the new rule. Dave's then going to tag up and talk about the test factors in detail. And boy, there's a lot of detail. And detail here, especially in the preamble to the regulations, really makes a big difference. We're also then going to close with Mike talking about sort of key takeaways and action items as you look to the year ahead. Along the way, we're also going to try and play a game of animal, vegetable, employee, or contractor. And to do that, all you need to do is take out your phones. And this is actually an interactive polling section. It's anonymous, so we won't see your names. But we'll have different multiple choice questions when we get to parts of the program. And to participate and actually sort of register your answer, all you need to do right now is to text the word DOL to the number 22333. And when you do that, you should get a little prompt that says you've joined the McGuireWoods session DOL. Don't need to do anything else until we get to that session. But right now, if you want to sort of prep for that, go ahead and text the word DOL to 22333. So, as we start to wrap our minds around the new independent contractor rule and why, frankly, the changes really matter, I think it's helpful to start with a couple of basic items. First is, that when you think about, independent contractor tests, and this is not only for the DOL test, but for other tests as well, what really matters is the core part of the factors that we're going to dive into, not the titles and sort of basic fundamentals of the structure itself that you may choose to impose on contractors versus employees. So, for example, whether or not an individual is an employee or an independent contractor is not a matter of title. Just calling them a contractor doesn't make them so, even if you call them a contractor in the form of a written agreement. Likewise, whether an individual is an employee or independent contractor is not a matter of choice, even if the individual voluntarily raises their hand and says, I do not want to be an employee. I want to be an independent contractor. Their voluntary choice, even if it's their preferred choice, doesn't make it so. And there's lots of case law that says that that choice doesn't actually override the test. Likewise, whether an individual is an employee or a contractor is not a matter of an agreement, even if it's in written form. Now, we like written agreements, and there are lots of good reasons to do them, which Mike's going to talk about later. But simply putting it in the form of an agreement, again, doesn't make it so. And likewise, the DOL has always been very clear that employees cannot waive their rights as an employee if you're trying to deem them to be an independent contractor under an agreement. So even if they say, I want to be a contractor, I voluntarily raise my hand and want to do it, I'm under no coercion, and I hereby release you from any claims related to being an independent an employee, because I, in fact, am an independent contractor, that doesn't do it, believe it or not. Likewise, how you pay somebody is certainly a consideration, but the fact that you simply 1099 them and issue that forth doesn't, again, sort of make that an independent contractor. As for why it matters, well, we're going to get into some more of the details, but just as a quick reminder, it affects a couple of different things. Whether an individual is an employee or a contractor, first and foremost, impacts you as an employer about whether you, on a macro basis, are covered under certain rules. So you have to have 15 or more employees to be covered under Title VII, or 50 or more employees to be covered under the Federal Family and Medical Leave Act. But that's employees proper, not independent contractors. Likewise, on the individual level, when you're thinking about individual workers, your status as an employee or a contractor affects all sorts of different protections, whether that's EEO, minimum wage, which we're going to talk about, overtime, OSHA and safety requirements, government mandated leave and work rates that may or may not apply, workers' compensation, et cetera. Those are things that attach to employee status typically, not independent contractors. Likewise, whether an individual is an employee or independent contractor affects a lot of other things. It affects your coverage under the Affordable Care Act, it affects ERISA and COBRA rights, third-party benefit eligibility under your insurance and other plans. It affects taxes, which the IRS is certainly keen on, and whether you're going to be eligible for unemployment compensation under individual state laws. The other thing to keep in mind is, and this is really important, and certainly I know Dave's going to talk about this and so will Mike, but I'm just going to go ahead and stress from the outset, at the end of the day, the independent contractor test really depends in part on who's asking. And so, for example, the Internal Revenue Service has its own test and a series of case law and history about how it views whether you're an independent contractor or employee for purposes of payroll taxes, et cetera. The National Labor Relations Board has their own test. The DOL is the test that we're going to be talking about, but the EEOC has their own test, and so do state and federal courts. And again, we're going to talk about more on the state and federal side at the end, but keep in mind there's lots of history, lots of case law about this test on the DOL side and the non-DOL side, and the tests don't always match, even on the federal level, which can be frustrating. What we're talking about today, and again, just to try and keep in mind, what we're talking about is the coverage today under the DOL's new independent contractor rule, and that applies specifically to who and is not an employee for purposes of coverage under the Federal Fair Labor Standards Act, or FLSA. So that's the rule that governs minimum wage, overtime, and record keeping, again, on the federal level. But again, that's not the test that's used for taxes. That's not the test that's used for national unionization. It's not the test that's used for non-discrimination coverage. They're similar, but they're different in many ways. And some of the rules, frankly, are less generous, and some of them are more generous from the employee side. And so this is important to know, especially for you small employers who are joining us. A lot of times, people will pass, an employee list or a worker list, and they'll run questions by their accountant for an assessment about whether they're covered for purposes of tax and IRS rules. And that's great, but that does not mean that if you get a blessing on that it's okay necessarily for the DOL's FLSA rule. It might be, but the DOL, even in their latest FAQs on this topic, were very clear that you can be an employee for purposes of the FLSA, even if you're not a employee for purposes of tax, or vice versa. And not that that's a great idea from a payroll standpoint, but it's technically separate tests and separate coverage. As for history, you may be asking yourself, didn't we just do all this before? And the answer is yes. This has actually been sort of regulated and gone through sort of rule making as recently as 2021. The odd thing about it, though, is before 2021, there actually was no DOL regulation or formalized rule. There were guidelines, for example, that were issued under the Obama administration back in 2015. There were also lots of DOL opinion letters on the topic, lots of case law, but never a regulation. During the Trump administration, they actually went through rulemaking, and they came up with what they deemed to be a sharpened sort of economic realities test, which we'll talk about just in a moment. But it really focused on control and a worker's opportunity for profit and loss. When the Biden administration took over, they rescinded that rule after delaying it, which then threw it into litigation. That action was sort of stayed as a potential violation under the Administrative Procedures Act. To get around that, the new administration then went through a brand new series of rulemaking. That proposed rule was issued back in October. The comment period closed in December of 2022 after getting over 55,000 different comments. And then the final rule that we're talking about today was then published on January the 10th, 2024, with a technical effective date of March 1. I say technical because there are lots of challenges to this already that are pending in a couple of different sources, including the original court in Texas who stayed the Biden administration's earlier action back in 2022. Whether we get a stay to these rules before March 1, we'll have to see. It sort of depends. There are a couple of different ways that the court's going to attack this, most notably for the fact that the current Secretary of the Department of Labor, there's some chatter about whether she really has sort of official authority to issue these rules since she hasn't been affirmed by the Senate after a couple of attempts prior. So we'll see where that goes. But if you're planning ahead, technically, the effective date for now is March the 1st. So again, as a refresher, if you go back to the 2021 test, this is the test of the Trump administration. Trump administration tried to sort of simplify the test. They looked at different factors, which you'll hear echoes in the current rule, but they basically said, look, when you pare it all down, what really matters is control and the worker's opportunity for profit or loss. And there are other guiding factors too, the amount of skill involved, the degree of permanence, whether the work is part of an integrated unit of production. But really the core factors are number 1 and 2, and the other factors are sort of supporting, but they're not the primary factors. And they base this on different courts that sort of held similar standards. And frankly, they were trying to simplify the rules so people could sort of have a clearer guide, at least in their mind, about whether people were in or out of the employee versus independent contractor bucket. The new test, at least from the agency's viewpoint, is different. From their viewpoint, if you look at the preamble, you look at the press releases that came out here in January, the DOL says, well, you know, that's all fine and well, but we really didn't like that test. And we didn't like it in part because we thought it went away from, quote, a multi-factor analysis that had been, quote, used by courts for decades. And we want to make sure that all the relevant factors are analyzed and not just a core set of factors. That's one view. The DOL also said, well, you know, we think the new final rule is not only consistent with the FLSA and decades of case law interpreting it, but it's more robust than the department's earlier sub-regulatory guidance on the topic, i.e. the Trump rule. So what do you think about that? Well, you know, at least, you know, from Dave's perspective, from Mike and my perspective, I think it's probably partially true, partially false. You know, there's no doubt that they're restoring a multi-factor analysis. Of course, I would argue the core factor analysis also had a multi-factor test. I also would argue that a lot of courts have, I think, correctly said that control really matters and ought to be one of the primary factors if you're going to weight other factors against themselves. Here, they're really moving away from that, and they're going back to a multi-factor analysis, which Dave will talk about, has no particular weight. The weights are all to be deemed applied consistently across all 6 factors, believe it or not. So that is a big change. I think whether or not it's consistent with decades of case law, well, again, that depends on the court you ask. So not so sure about that. And as Dave will talk about, when you get into the factors, there are some factors, in fact, that are huge changes when you actually look at the details themselves. So as for the definitions, the big change is the definition itself. employee from DOL's perspective under the new test is defined broadly as any individual whom an employee, quote, suffers, permit, or otherwise employs to work. Well, that's an old test, an old reference under the FLSA, so nothing unusual there. And who, as a matter of economic reality, also an echo to the old test, is economically dependent on an employer for work, not for income. Well, that's a little different. And then they say, well, an independent contractor is defined as a worker who, as a matter of economic reality, is in business for themselves. And so from their perspective, it's that dependence that's, quote, the ultimate inquiry, not control, not other factors we're going to talk about, but the dependence. And they say economic dependence does not focus on the amount of income the worker earns or whether the worker has other sources of income. So if you think about that and step way back before you even get into the factors, again, from our perspective, this rule is biased in favor of employee status by design. That was one thing they said in their press release. That's true, that they wanted this to be, quote, a more robust test. But from their viewpoint, more robust means more employees, not more independent contractors. The other thing that I'll say, again, on a macro level before we get into the factors, what makes this hard is, part of the test and part of what you're seeing for yourself when you're trying to apply whether the factors do or do not lean towards independent contractor status when you're looking at individual scenarios for individual workers. Certain bits of information on your own, but there are other parts you have no clue about, whether someone is truly dependent on you and you alone for work. Well, you know about control, you know about skill, you know about the work they're assigned, you know about the restrictions you place on that, but whether they work solely for you, how they do their outside work, how often they do it, for whom they do it, you may have no clue. But now that's going to be a question of whether or not they're, quote, dependent on you for work. And I would assert that that is a big strategic shift. So the factors themselves, which Dave's going to go over, the opportunity for profit or loss depending on managerial skill, item number one, investments by the worker and the potential employer, the degree of permanence of the work relationship, the nature and degree of control, the extent to which work performed is an integral part of the employer's business, and the skill and initiative of the worker. Those are the 6 factors that are part of the new test. They're an echo of other factors you've probably all heard before. They're a little bit of an echo of parts of the IRS test, so nothing shocking. The shocking part is really sort of the details of the factors. So before we jump to the factors, let's play our first game of employee contractor, or excuse me, animal vegetable employee contractor. So if you haven't already, go ahead and text the word DOL to 22333. If you've already done that, no need to do it again. If you haven't done it, go ahead and text the word DOL to 22333. So here's our first question. So animal vegetable employee or contractor. So we have an individual who provides services for a small housing organization. They're on call 24/7. It's sort of a rolling, ongoing commitment. Their job is basically to provide security. They identify active, potential, and imagined threats. They can work with or without managerial oversight. They're subject to a lot of organizational rules related to discipline, actual and reserved. They really don't have much business investment beyond basic time and labor, and they receive paid meals, room and board, and health care. So, animal, vegetable, employee, or contractor. Just text A, B, C, or D to the number 22333. Okay, we seem to be moving around. Looks like a lot of people think employee, few people think contractor, few people think vegetable. I'm not sure what vegetable that would be, but well, the answer is it's my daughter's dog. That would be animal. It sounds a little bit like an employee, but it's actually an animal. So good test. Before we jump to the factors, let me try another one. Animal, vegetable, employee, or contractor. This is a chef. a real live chef, not a dog chef, who provides services for a women's shelter. The residents cater for local businesses as part of job training and recovery. The chef itself has different degrees, certain state certifications, no written agreement with the shelter, but they do have a DBA filed with the state. They're paid on an hourly basis, but it's on a sliding scale depending on the event size, so it's not static. They work at the shelter's kitchen with the residents who are paid a minimum wage, but the chef provides his own uniform, chives, knives, and recipes, but otherwise uses the shelter equipment. The shelter itself markets and selects the catering assignments, but the chef has his own business. He does other things. He separately markets his own meal preparation and catering services, and he has other clients. But the week is recurring. It's sort of sporadic, but it's recurring. And because it's recurring, he has sort of on again, off again work for other clients because of the time demands. He's been doing this for over 2 years because they like him. But at the end of the day, if a given assignment doesn't work, he can decline the shelter assignments. So animal, vegetable, employee, or contractor. What do you think? A, B, C, or D? Starting to get some answers in. So it looks like starting to shift. So it looks like a lot of people think that the individual is most people think the individual is a contractor and not an employee, and it's certainly not at all. Interesting. Probably under the new test, and Dave's going to talk about this, I think things have shifted where this individual probably, at least under the new test, is going to be deemed an employee. Under the old test, frankly, I think it's a lot closer question, and the individual would have been deemed a contractor. Some of the things that makes a difference here under the new test, the chef is providing services that are a core part of what the shelter does. Now, the shelter is really there to provide recovery for women, right? But they have this whole side operation where they do regular ongoing catering, and that catering is a core part and tied into what the chef is doing. He's not providing accounting, he is providing catering services in connection with them. Doesn't help, by the way, that the residents are also being paid to do similar work. Doesn't help that he's also at their own kitchen, not doing it off-site, using most of their tools, equipment. Doesn't have a written agreement, not helpful or hurtful necessarily, but it's certainly not a great fact. But the big part of it is the shelter sort of markets and selects the catering assignments and not vice versa. He's really tied into their investment. And likewise, he's so tied into their investment that DOL may likely view him to be, quote, dependent on the women's shelter for work. So even though he has his own business, even though he works for other people, from DOL's view, that's great. But as to this particular entity, you can still be an employee and have a whole separate sidekick that is a contractor status for others, but not for some. And to me, that's what really makes this test really difficult. So with that, I'm going to turn it over to Dave to dive into the factors and sort of why we sort of come up with this decision and sort of how we sort of navigate around it. Dave?
Thanks, Brian. Before we walk through the 6 factors in the DOL's new final rule, Brian, I just thought I'd make an observation, which is that I suspect there are some in the legal community and perhaps even some on today's who have joined us today who find the topic of independent contractor classification a little dry, perhaps even a little esoteric. But I know that I speak for Brian and Mike and certainly myself when I say that I don't find it that way at all. I find this stuff very, very interesting because really we all know that there's an infinite variety of working relationships from your Uber driver to your over-the-road truck driver to an accountant to a welder to an exotic dancer and anything else you can imagine. And those relationships have an infinite variety of factors and dynamics going on. And the challenge for the DOL and the other agencies that Brian mentioned is to draw a line where we're going to put some of these relationships into one bucket and some into another. And it's such an interesting and also such an important question, as Brian outlined. Where are we going to draw that line? And so that's really what we're doing as we talk through, as we take a journey through these 6 factors. These are the 6 factors that the department says we should look at, but we always need to keep in mind that the ultimate question is one of economic reality. The ultimate question is, under the totality of the circumstances, is this individual economically dependent on the potential employer? So we have 6 factors that the department says should guide our inquiry, but the department is clear that the 6 factors we're about to review are not exhaustive. There could be others. What other factors could there be? Well, the limits are as broad as your imagination. But if you can come up with a persuasive reason why there's a factor that is probative of the economic reality of this worker's situation, then according to the DOL, it should be considered, because this is a non-exhaustive list. And as we look at these 6 factors, certainly if you have any experience in this area, these are familiar factors. They're present in many tests, used in many jurisdictions. So there's nothing here that's going to surprise you or come out of left field. But the big difference, one big difference between our new factors and the ones from the department's previous test, the 2021 test, is that we have no core or weighted factors. No one factor is going to be primary or more important than another. So this is contrary to the prior rule, and really contrary to what we're familiar with from common law, where control was always front and center, and there were other factors you could look at as needed in a given case. But really, we're used to, in many situations, seeing control be front and center, as it was in the department's previous rule. It's no longer front and center according to the department. So as we go through these 6 factors, just always keep your eye on the ball, that the question is not necessarily this factor or that factor. Those factors are guideposts to the economic reality. And the question that the department is really asking is this worker in business for herself? And so a question I would invite you to consider as we go through this, and Mike and Brian, maybe I'll ask for your opinion on this at the end. Would it be fair to say that the department's new rule could be described as an independent entrepreneur test? That's a question that I think is important to ask, and that may be helpful as we look at these factors. Brian, if you want to advance the slide. So our first factor is the opportunity for profit and loss. And you can see on your slide some sub-inquiries that the department says may be relevant to this factor. So I want to unpack the factor, because there's really 2 parts to it. First, we're looking for an opportunity for profit or loss. If there's no opportunity for profit and loss, then this factor is going to suggest that the worker is an employee. So if the amount of pay is relatively fixed, if the worker has nothing invested and therefore nothing potentially at stake that he or she could lose, this factor is going to point towards an employee, not an independent contractor. But that's not enough. Let's say there is an opportunity for profit and loss. That alone is not enough, says the department. They say that opportunity must be based on the use of managerial skill. And that's really where these 4 questions that you see on the slide come into play. So the department's going to ask whether the worker can determine or negotiate the rate they receive for the work. Can they accept or decline jobs, choose the order in which they perform work? Do they engage in marketing or efforts to expand their business? Does the worker hire others, purchase material or equipment, or rent space? So those are all inquiries that'll help us figure out whether the worker has an opportunity for profit and loss based on managerial skill. Another helpful way to look at this factor is, what is not managerial skill? What will not qualify, in the department's opinion, as managerial skill? Well, we know, because the department has told us, that mere technical proficiency in completing a job will not qualify as managerial skill. And this is perhaps a little bit surprising, because technical skills have economic value and they may create independence. If an individual has skill in computer coding, They may be able to leverage the value of that skill into profit. If an individual is skilled at welding, they may be able to leverage that skill into profit based on its value in the market. But the department says that technical proficiency alone isn't going to tip this factor in favor of independence. Also, what is not managerial skill, according to the department? Ability and willingness to take on more work in order to make more money is not managerial skill, according to the department. And this also might come as a surprise. You might think that the ability and willingness to work more for more money is an entrepreneurial characteristic. You might think that the ability to make time for more work and get that work done is in fact a managerial skill, but the department says not so much. So the ability to work more or the willingness to work more for more money is not managerial skill, according to the department. So if we go back to the welder who I mentioned earlier, imagine a welder who performs welding work as needed for one or two local companies, but for whatever reason, he has no interest in marketing his services. He has no interest in hiring any helpers. He charges whatever rate the market allows him to charge for his services. It's hard to see, at least on that factor, at least on the profit and loss factor based on managerial skill, how this factor could tip in favor of independence. Now, again, the department says, look, it's the totality of the circumstances. So we would need to know a lot more about our welder to know, what the department would likely conclude as to his status. But at least as to profit and loss, absent some sort of entrepreneurial urge to market and hire and expand, the scale on this factor could certainly be understood to be tipped against independence and in favor of employee status. And Brian, next slide. Our second factor is the investments by the worker and the potential employer. And this is now a standalone factor, whereas in the 2021 rule, it was combined with opportunity for profit and loss. It now stands alone. But you can quickly see that it's going to overlap with the opportunity for profit and loss, because in order to have an opportunity for a loss, presumably there has to be some sort of investment. If you haven't invested anything, you don't really have much to lose. So there's certainly going to be a blurred line between these first two factors. But what the department tells us to look at is whether the worker's investment is capital or entrepreneurial in nature. And the focus is on the type of the investment, not on the relative size of the investment, right? Because if the focus was on the dollars invested by the individual worker compared to the dollars invested by the large business, that it would be hard to imagine how those relative investments could suggest independence. So this is, according to the department, a qualitative, not a quantitative factor. So what do you mean by that? Well, the department in its preamble to the rule gives a couple of examples. If you consider a driver who owns or independently finances a truck, that driver's investment is very similar to that of the trucking company that has a whole fleet of trucks. And so while the driver's investment is smaller, his investment is sufficient that that driver could operate independently, and this factor would suggest independent contractor status. Another example the department gives us is a photographer. She has cameras, equipment, photo editing software, not nearly as much as a large photography company would have, but enough that she could operate independently. And so the department says there, that factor again is going to suggest independence. And Brian, next slide, please. So basically what the department is telling us is if the investments increase the worker's ability to operate independently and operate her own business, this suggests independent contractor status. But there's certain investments, according to the department, which don't count, which you shouldn't hang your hat on. One of these, one investment that you shouldn't count is costs that are unilaterally imposed by the potential employer. As you see that on the screen, the department says these aren't capital or entrepreneurial in nature, so they don't suggest independence. Similarly, costs that the worker incurs for tools and equipment to perform a specific job are not capital or entrepreneurial in nature. They don't suggest an ability to go out and operate independently, so they're not going to weigh in favor of independence under this second factor. And as you see on the slide, this is one of these areas where, as Brian told you, the answer to the question depends on who's asking. Because the IRS says that the extent of the worker's investment in the facilities or tools used in performing services does suggest independent contractor status for the IRS's purpose. So it highlights the fact that we need to know, to answer the question, we really need to know who's asking it. And then we can figure out how's that question going to be analyzed by that agency or that entity. But again, I think what we see here is the department is looking for evidence not only of investment, but of a particular kind of investment, an investment in entrepreneurial activity. And the question that comes to my mind is, does this mean that only workers with capital to invest can be independent contractors under this factor? What if I'm a worker without any capital? Or what if I'm a worker who doesn't need an investment to operate my own business? So I think of a computer programmer who has an inexpensive laptop and uses it to write computer code. In that case, it's difficult to see this factor weighing strongly in favor of independence. Or I think of an adjunct professor who goes around and teaches medieval literature at various area colleges, but needs no equipment to do that. She hops in her car and drives around and enters the classroom and teaches. It would be difficult to see how the investment factor, at least, is going to suggest independence for those workers. Another example that the department gives in its preamble of an investment that does not suggest independence is your personal vehicle. So the question was asked, what if a driver has a car, they use it for their personal conveyance, and they decide they're going to use it to start some sort of business? Maybe it's ride sharing, maybe it's delivering food, maybe it's delivering freight, which is a common situation. And the department says no. The department says your car is not a capital or entrepreneurial investment. So I think what we see as we look at the factor and then as we unpack how the department says it will interpret the factor is that it's going to be difficult. There's a thumb on the scale right off the bat against many types of investments that in the department's view do not suggest economic independence. And in addressing those concerns and those comments, which the department did in the rulemaking process, the department said, well, yeah, we understand your concern, basically, but look, stop your complaining. It's a totality of the circumstances test. And so even if this factor, doesn't go your way, it doesn't mean you've lost because there's other factors. That's my very, very loose paraphrase of the department's response to those concerns. Moving on to the third factor, which is the permanence of the working relationship. We want to note that the department is going to look at the degree of permanence both in duration, how long it lasts, whether it is for a fixed period or an indefinite period, and whether it's exclusive. So the department says an indefinite, continuous, or exclusive relationship suggests an employee status. A relationship for a definite period of time that's non-exclusive, project-based, or sporadic suggests a contractor relationship. Brian, could we have the next slide? And as you can see on the screen, the department then explains that basically an indefinite and exclusive period of a relationship is going to suggest employment, but a definite or non-exclusive period may not suggest independence if it's somehow inherent in the seasonal or temporary nature of the work by itself. In the department's words, operational characteristics that are unique or intrinsic to particular businesses or industries and the workers they employ are not necessarily indicative of independent contractor status. So just even though you have a relationship for a definite fixed period of time or a project basis, or you know that the worker you're talking about engages with other businesses, other firms, that doesn't necessarily mean that you're going to score a victory on the permanence factor, because the department could very well choose to disregard that evidence if the department decides that the definite or non-exclusive nature of that relationship is simply inherent in the nature of the work. And all this raises a question in my mind as well, which is this: isn't it true that workers in business for themselves often rely on long-term relationships with repeat customers? I mean, wouldn't that tend to be an indicator of a successful entrepreneurial independent contractor? And in response to concerns and questions along those lines in the preamble to the final rule, the department recognized that, acknowledged that that's certainly true, but left unclear how to account for that reality when you're analyzing the permanence of the relationship under this factor. Brian, if we could have the next slide. So now we come to the control factor, which is familiar if you've worked in this area at all. It's always a central part of any independent contractor test. But I think three things stand out in the department's new iteration of the economic realities test. So number one, control is now just one among several factors. It's not a core factor. It's not the first factor. Not even numerically is it the first factor. It's not given any more weight or any less weight, by the same token, as any other factor in this test. Number two, the department is clear that when they look at control, they are going to look at not only actual but also reserved control. And you say, what do you mean by reserved control? What I'm talking about is a right to control, typically contained in a written agreement, that may never actually be exercised, but which is out there. And so if that right is out there, whether it's used or not by the potential employer, the department is going to put that as a weight in the employer side of the scale. Third, the focus is going to be on the potential employer's control, not the worker's control. And the focus is on control of economic aspects of the work, not on the details of the work. So what types of control are relevant according to the department? As you see on the slide, does the potential employer set the schedule? Do they supervise the performance of the work? Do they limit the worker's ability to work for others, whether those rights are exercised or only reserved? So when we talk about performance, or when we talk about supervision, the department tells us that control will include whether the potential employer uses technological means to supervise the performance of the work. What exactly does that mean? Well, an example that I think of is if a delivery driver operates as an independent contractor and the trucking company keeps track of where that driver's truck is for purposes of providing an estimated time of arrival for the freight, that collection of data, that technological means to supervise and know where the driver is, according to the department, is not, might not be control, but if it was used in if that technological means to supervise was used in a different way, it could be evidence. So if you're looking at data, technological means of knowing where the workers are or what they're doing, the question is a collection of worker data, which may not necessarily be control, or is it a technological means of supervision, which could be different according to the department? Could we have the next slide, please? The department has explained that under the control factor, actions taken by the potential employer for the sole purpose of complying with specific federal, state, tribal, or local laws or regulations are not indicative of control. On the other hand, actions taken that go beyond such compliance may indicate control. What exactly does that mean? Well, if you think of a home health care aid, and this is one of the examples the department gives, the potential employer requires a background check, which is necessary to obtain a license, which is required in the jurisdiction. if all that the healthcare company has done is comply with applicable laws, that doesn't indicate control by the employer. If anything, it indicates control by the federal, state, or local jurisdiction. However, if the company goes beyond that requirement and requires a more robust background check or other certifications that aren't required by law, that may indicate control. Or if we think of the construction industry, if you have a construction site in a locality that has a hard hat ordinance requiring your independent contractors to wear a hard hat is not necessarily going to indicate control. But if you go beyond that legal requirement by having a required weekly safety briefing, that may, in the department's opinion, suggest control by the potential employer. Could we have the next slide? Our next factor is the extent to which the work performed is an integral part of the potential employer's business. And this is a question that doesn't focus on the individual worker, it focuses on the function the worker performs. So the question here, according to the department, is could the potential employer function without the service performed by the workers? If the answer is no, the employer would be unable to function without these workers, then the work is integral, and that's going to suggest employee status. So the example the department gives in its preamble is you have a farm producing tomatoes. The folks who go out and pick the tomatoes are integral to the farm's business, and this factor will suggest employee status. However, an accountant who prepares the farm's tax returns is not integral, and so this factor might go a different way according to the department. Now, you can make an argument that a business that does not prepare and file its taxes won't be in operation very long, and so the accountant, in fact, is integral. But the department says, no, what we're looking at is whether the work is necessary to the principal business, not sort of the administrative overhead of the business. And the next slide, please. Final factor, the sixth factor in the new rule, is the worker's use of skill and initiative. Skill and initiative. And here again, what we see as the department unpacks this for us is that the department is looking for entrepreneurs, because you need two things here to satisfy this factor for independence. Not only skill and initiative, that alone won't be enough, but skill and initiative that contributes to business-like initiative. So again, technical skill alone isn't going to be enough, says the department, because employees may be skilled. But that's not, in the department's mind, enough to render them economically independent. So the example that the department gives in its preamble is a welder. Say you have a welder, she performs her work for a construction firm, she takes assignments as they're available in the order assigned, she has technical skill, but no evidence of any business initiative, so this factor at least will suggest that she is an employee. But the same welder, says the department, if she welds for a number of different construction companies, if she uses skill to market her services and to get new work, that's technical skill applied to business initiative, and that may suggest independence. So, and again, the question that comes to my mind is, to take our now familiar example of the welder, if we have a welder and she has all the work that she wants from one company, she has no interest in marketing her services, she doesn't want to hire anybody, she doesn't want to manage, she doesn't want to work anymore, why would this factor cut against her independence? But the department seems to be saying in its rule and its explanation of the rule is that that's welding skill alone, without some evidence of it being applied to business-like initiative, is going to perhaps land on the side of employee status, although I think the department would then say, but you need to remember it's totality of the circumstances, so we're not going to look at any of these factors in a void. And the next slide, please. And finally, I wanted to take a quick look at the seventh factor, which has been eliminated in the new rule, which is the worker's degree of independent business organization and operation. Basically, the labels that are applied, and that means whether you give the worker a 1099 whether you require them to form a business entity like an LLC. Those are all not going to really be part of the department's analysis. And in fact, if you look at the very last bullet point on slide 34, the department says that if a potential employer requires certain licenses or certain forms of businesses, not only is that does not suggest independence, it may be suggestive of control. Hope you've enjoyed our journey through the 6 factors, and I'm going to turn it over to my colleague Mike Phillips, who I think is going to return to our favorite game, animal, vegetable, employee, or contract.
Yes, exactly. Let's do one more round, and we'll see what everyone's learned from the rundown of the DOL factors. If you participated in the poll before, you should be fine. If you have not participated in the poll already today, text the word DOL to the number 22333. You'll get a response and you'll be able to join our poll in our game. Go ahead, Brian, next slide. There we go. So, is this person an animal, vegetable, employer, contractor? He's a freelance writer. He provides services for the corporate communications department of a chemical manufacturer. He's got a contract that's 12 months, but with rolling extensions like an evergreen contract, so it automatically renews unless somebody terminates it or non-renews it. He gets paid a monthly fee, but no benefits, gets 1099, works from his home, uses his own laptop, his own software, sets his own days and hours of work, but he's required to post website content on topics that the company designates. He's expected to be in attendance at monthly marketing meetings. He's required to adhere to copyright law and to the company's electronic communications and IT policies. He's got a general quota, which isn't a requirement, but anticipated to turn out 3 posts or articles a week. The company reviews his work prior to it getting posted, and he can write for other clients, but he's not allowed to work for competitive United States chemical companies. Let's go to the poll. All right, folks, A, B, C, or D. Is this person an employee, a contractor, an animal, or vegetable? All right, looks like contractors gaining a little bit, but somewhat of a majority say that this individual is an employee under the test, and a minority, about 60-40, 40% think he's a contractor. Brian, let's go ahead and show what we think. We said he's likely a contractor, but it's a close call under this new test. So I think the 60-40 polling was pretty accurate on this. And those of you who said that this individual is a contractor probably relied on the parts of this that are not highlighted. In other words, he gets paid a monthly fee, he gets a 1099, he works from his own space, he uses his own laptop and software. He sets his own hours and days of work. He's got a quota, but it's not a requirement. And he can write for other clients. Those are all good factors that show that somebody is, in fact, a contractor. Those of you who felt that he was probably an employee were probably thinking about some of the highlighted areas here. He uses his own laptop and software, but there's not a lot of cost and investment in this business. The company tells him what topics to write on. He's got to be at monthly meetings. He has to adhere to copyright law, and that's okay because that's compliance with law, as we talked about. But he also has to comply with the company's policies, and that's outside the scope of legal compliance. It's a factor that indicates someone's an employee. The company edits and approves his work, reviews his work, and supervises him. That's a control factor. And even though he can work for other companies, he's not allowed to work for any competitive U.S. chemical company. Again, a control factor. So this illustrates a couple things, but one of which is how difficult sometimes this test can be to apply, and that you're usually going to have factors that cut both ways. Brian, in the interest of time, could we advance 2 slides? All right, so some takeaways from our discussion. As we mentioned, the new test is designed and biased in favor of making more people employees than contractors. And this includes people who want to be independent contractors. And that may be true in many workplaces where somebody wants to be a contractor and not an employee. But as we mentioned earlier, it's not a matter of choice. The Department of Labor will view somebody who meets the criteria or where the factors weigh in favor of employment status as an employee for FLSA purposes. The lack of key factors, no factor is more important than the other, makes it harder to apply this test, makes it more subjective, makes it more likely that you're going to get inconsistent results. But one point that's important is that this is an interpretive rule. A court can follow the rule, but they're not required to do that, not required to grant deference to the rule. And as some of you may know, there's a major controversy going on right now at the Supreme Court about how much deference any agency rule is entitled to. The federal courts have been deciding these questions for decades and decades. They've got their own case law, their own tests. States have their own tests as well. Some of them are actually less favorable for contractor status than the new DOL test. Some are more. But we anticipate that courts and states and other agencies that are not the Department of Labor are going to continue to apply their own test. The Department of Labor, though, will use this rule as part of their audits and enforcement. So if you're dealing with a Department of Labor audit or a complaint to the Department of Labor, this is the test that's going to be used. Go ahead, Brian. So just a few things to think about. Whenever the law changes like this, a good time to look at your company's procedures for engaging independent contractors. And do your independent contractors meet this test? Are they really going to be contractors? Think about a policy. Some companies have policies that place limits on the roles independent contractors can play and the terms under which they can work. You can adopt a policy that tries to comply with these factors, and that can be helpful if you're audited or if you're sued or if you get a complaint. It's possible that this law is not going to go into effect for a while. It might never go into effect, depending on what happens in the courts and in the upcoming election. So keep an eye out on the news about the litigation that's pretty much inevitable, I'd say, at this point, and whether this rule gets stayed or really goes into effect. Think about your contractor agreements, and is there language you can put in your agreements or take out of your agreements that will help you comply with the new standard? And then can you change the way that you pay workers? Can you change the way that you treat your independent contractors? Or do you need to reclassify certain people and shift them from independent contractor roles to employee status? Brian, if you go 2 more slides. All right, and a few more resources. I'm sure that this will stimulate you to learn much more about this rule. If you're interested in that, you can read the rule itself. It's only 106 pages long, published in the Federal Register. That's the third link here. There's a few more concise informational sources that we would also recommend if you want to learn more about the rule. We don't have time for questions, unfortunately. I know there's a few in the chat, but we'll happy to answer questions or follow up with folks. And then if you need to reach out to us, our information is right here. So thanks everybody for joining our webinar. It was a pleasure to speak to you today on behalf of Brian and David and our folks here at McGuireWoods. We appreciate you joining.